Welcome back, everyone. 15 after the hour, and time for us to go behind the headlines and take a look at Florida's medical marijuana amendment. The Kathy Jordan Medical Marijuana Act is currently in the signature gathering phase. The people that are united to try to get this passed say they have about half the signatures they need already. And of course, John Morgan, the high-profile, high-dollar attorney in Orlando, who is currently backing Charlie Crist to become the next governor of the state. He's thrown a lot of money behind this, about $600,000, and plans to have about $1 million or more to continue the fight. However, before we ever get a chance to tally all the signatures, get it on the ballot, campaign for it, and get medical marijuana passed as a constitutional amendment in the state of Florida, we have a major hurdle to overcome. This week at the Florida Supreme Court, they are hearing arguments having to do with the ballot summary and other issues that may cause the Florida Supreme Court to declare this amendment unconstitutional and refuse to allow it to go forward on the ballot. What's at stake here is the definitions that have to do with who can get medical marijuana. The Speaker of the House there in Florida, Republican Will Weatherford, and understand that Florida is a Republican-controlled state right now, said his opposition stems only from concerns about how the ballot proposal is constructed, according to WOKV TV or WOKV radio, I think, in Florida. He said, quote, this is what he told the Palm Beach Post, quote, "It's misleading to voters, flawed, and doesn't really tell you just how pervasive marijuana would be in this state. If this were approved, it would be a nightmare for the legislature to implement," end quote. And what is at issue here before the Florida Supreme Court is whether or not the ballot summary is misleading to the voters. And in particular, the part of the ballot summary, I'll read to you the full ballot summary is this. This law would allow the medical use of marijuana for individuals with debilitating diseases as determined by a licensed Florida physician. Allows caregivers to assist patients' medical use of marijuana. The Department of Health shall register and regulate centers that produce and distribute marijuana for medical purposes and shall issue identification cards to patients and caregivers. Applies only to Florida law. Does not authorize violations of federal law or any non-medical use, possession, or production of marijuana. That's the summary the Florida Supreme Court is looking at. And the major part is at the very beginning there where it says, allows the medical use of marijuana for individuals with debilitating diseases as determined by a licensed Florida physician. Attorney General Pam Bondi, who's also a Republican, has challenged this law in front of this summary in front of the Florida Supreme Court because of what she says is misleading language. She says that this only for debilitating diseases is obfuscating the fact that this medical marijuana amendment would actually allow medical marijuana for almost any condition. Here's the definition as written in the medical marijuana amendment. For the purposes of this section, the following words and terms shall have the following meanings. A debilitating medical condition means cancer, glaucoma, positive status for human immunodeficiency virus, HIV, acquired immune deficiency syndrome, AIDS, hepatitis C, amyotrophic lateral sclerosis, or ALS, Crohn's disease, Parkinson's disease, multiple sclerosis, or other conditions for which a physician believes that the medical use of marijuana would likely outweigh the potential health risks for a patient. And that last clause, other conditions for which a physician believes the medical use of marijuana would likely outweigh the potential health risks for a patient, is what Pam Bondi is pointing to, saying that basically that is a very California-like statement. Of course, California famously in 1996 allowed Prop 215 to go forward with the language that said any other condition that a doctor believes marijuana can assist with. She believes that this would cause the same effect in Florida, where basically anybody who's got $40 in a story can find a doctor who's willing to recommend them medical marijuana. Now, this was brought up by one of the legislators there in Florida, and Florida's PolitiFact looked at this statement and agreed basically with the Attorney General and the Republicans in the State House that there was some fudging going on here with this ballot summary, that it was kind of confusing to people that would think it was only for cancer and AIDS and hep C and so on, but would be allowed for just about any condition. Now, of course, I support medical marijuana for any condition, but if the Florida Supreme Court decides this is misleading, nobody will get medical marijuana in Florida. So it just goes to point out here that be careful how you construct these laws and these ballot initiatives, because trying to get clever and trying to sneak in any possible condition might mean that nobody gets medical marijuana, and that doesn't help us. All right, we got to take a break. When we come back, we've got Electric Bob on the line for our Daily Toker Tunes.
If he said he swam to China, he would sell you south.